Okay.
Okay, we are now recording. All right, welcome everybody. My name is Ava Ayers. I am the director of the Government Law Center and a member of the faculty at Albany Law School. And I'm very happy to welcome you to the last in our 2021 series of Warren M. Anderson legislative seminars. My colleague, Richard Rivkin, the director of the Government Law Center, is going to be moderating today's panel. Before he gets started, I just wanted to share a couple of things. First of all, I want to thank our sponsors. We have three sponsors who supported the entire series this year. The Raffay Group PC, a donation in memory of Sharon P. O'Connor, Albany Law School class of 1979, and Brown and Weinraub PLLC. I also want to thank today's program sponsor, Hinman Straub. So a quick reminder, if you're an attorney and you've signed up for CLE credit, please make sure to fill out and return all of your forms to Lisa Rivage. Her email is lriva@albanylaw.edu, and I'll put that in the chat. We will have a program code at some point during today's program for you to enter into the forms. I also want to just say thank you because I am stepping aside as Government Law Center Director after 5 years. This will be the last time I moderate an Anderson seminar series. I'm going to be shifting into a full-time faculty role at the law school, which I'm very excited about, but I'm also sad to be leaving, and you'll still see me around working with the Government Law Center in quite a few ways. So to everybody who's been part of this journey, who's helped me and who's helped the Government Law Center during this time, thank you so much. And with that, let me turn it over to Richard.
Thank you, Ava. And I would just remind you that being a member of the faculty does not preclude you from being a moderator of one of our.
It certainly doesn't.
Welcome, everyone, to our final Anderson program of the year. Let me say that this year has certainly been a different year. I need not go into detail. And it's a year in which we have spent a good deal of time considering changes in many aspects of our future. For this Anderson series of programs this year, future policy changes have been our focus. The first program examined changes in police practices. The second involved a look at the potential of the states authorizing online gaming. Our third program considered changes in the way we cast our votes. And let me just add that the objective of these changes has been to enhance, not to diminish the right to vote. And today we examine potential changes in the judicial branch of our government. While the courts have been considering possible changes for some years, I think it's fair to say that the pandemic has forced expedited examination. The challenge in the past year for the courts has been to operate with as little personal contact as possible between judges, litigants, lawyers, staff, and jurors. With this model having been forced upon the court system, Chief Judge DiFiore appointed a commission to reimagine the future of the courts. Today, we consider what that future might look like. We have three outstanding speakers this morning, whom I'm very proud, and I thank them for participating. Chief Administrative Judge Lawrence Marks, who will give us some insight into the views that were developed at Beaver Street, the office of OCA. Hank Greenberg, former president of the State Bar Association. He was appointed by Chief Judge DiFiore to chair the commission to reimagine the future of the courts, and he will discuss the work of that commission. And finally, Lance Clark, the managing attorney at Cook & Clark in Nassau County. Lance will talk about what the future may hold for small firm practitioners. So I'm not going to go into the background or bios of our speakers. You have that in your materials. And rather than spending my time at that, I'd rather get to the substance of the program. And so let me open and turn the floor over to Judge Marks.
Hey, thank you very much, Richard. Thanks for inviting me to speak today. And what I thought I would do and would be helpful and maybe kind of set up the discussion is and provide some context, hopefully, is to talk about the court systems. And I'm going to do this, in very general terms, obviously, but the court systems experience in dealing with the pandemic when it first hit, and then sort of our progression through the pandemic leading up to the present. And then I'd like to talk a little bit, obviously, about where we see ourselves going in the future and sort of what aspects of what we've done over the past 14, 15 months, we maybe see continuing post-pandemic. And as I said, hopefully that will provide a context for Hank Greenberg, who I believe will talk about some of the innovative things that the commission has been evaluating and talking about. And then and Lance, I assume will, from the practitioner's perspective, will tell us what we're doing right and what we're doing wrong. And hopefully it's more right than wrong, but we'll wait to hear from him. So just actually, what if I could just very briefly start and take us back pre-pandemic to February of 2020. And we were in the midst of continuing our execution of what it has been the Chief Judge's top priority since she took office in January of 2016. That's what we call the Excellence Initiative. And we were basically 4 years into the Excellence Initiative in the days leading up to the pandemic. And for those of you not familiar with this initiative, it's a statewide comprehensive effort to improve the quality and the efficiency of adjudication in the New York State courts, with particular focus on attacking backlogs and delays in case processing. And it's very much a data-driven initiative. We, from the very beginning, started to collect extensive caseload data, county by county, court by court, judge by judge. We collect a tremendous amount of data. We review it regularly. We share it with judges and court administrators. And I don't want to get into the details of the Excellence Initiative, but let me just say it's really, it was a highly successful program. 4 years into it, there were broad improvements in attacking backlogs and delays and reducing the number of older cases in the court system across the whole state. At every level of court, there was broad progress in this program and dramatic progress in some places, reductions in older cases by as much as 90% in a fair number of courts throughout the state. So I think it's fair to say that the Excellence Initiative truly changed the culture of adjudication in this state, which is, believe me, not an easy thing to do. I've been in this business many, many years, but it's very fair to say that there was a change of culture in adjudication in this state as a result of the Excellence Initiative. And then the pandemic came along, and our focus turned from focusing on backlogs and delays to more existential concerns, literally, how do we keep the courts open and functioning during a pandemic? And, going back to the beginning in mid-March of 2020, which were really the dark days of the pandemic, as you all know, the first step we took was essentially we sent almost everyone home in mid-March, and we focused our exclusive attention on on essential and emergency matters. And this was an extremely difficult thing to try to define because every lawyer and every litigant thinks that their case is essential. And we agree with that, but of necessity, we had to narrow it down to, very limited number of proceedings. And we did that. And basically they were proceedings that raised serious public safety issues, raised significant constitutional issues for litigants. And examples of some of these essential emergency matters as we define them included arraignments of people who had been arrested and detained by the police, review of bail decisions that had been made, applications for orders of protection, civil commitment proceedings, determining whether people needed to be civilly committed because they presented a risk of significant harm to themselves or others, landlord lockout proceedings and things like that. There was a fairly concise list of what we defined as essential and emergency proceedings, and that was our total focus from mid-March forward. Within a week or so, we were able to conduct all those proceedings virtually, which was a tremendous achievement on the part of our technology staff. And that continued for several weeks, but we immediately, while that was going and working reasonably well, we immediately turned our attention to the rest of the 99% of the state court system's inventory, if you will, the non-essential, non-emergency proceedings. And by mid-April, within 3 to 4 weeks of the real onset of the pandemic, again, in a very short time period, we were able to expand court operations to include many court proceedings in these so-called non-essential matters. And so court conferences, motion arguments, also some evidentiary proceedings, hearings. And this was very successful and really continues to this day, where over 20,000 court conferences are held virtually by judges throughout the state, virtual motion arguments, as many as 4,000 to 5,000 decisions and orders, formal orders are issued by judges each week, as many as 1,000 or more evidentiary hearings. Very, very successful program. And then we, since not all court proceedings, and this is a primary focus of the program today, not all court proceedings, we believe, can be conducted virtually. We began to plan and eventually resume limited in-person court proceedings. And for example, in the summer of 2020, we brought back a limited number of grand juries. And in the fall, a month or two after that, we brought back a limited number of civil and criminal jury trials around the state. This is the fall of 2020. And then with the resurgence of the virus, late fall 2020, we were forced to suspend again most of these in-person proceedings, although including the jury trials, civil and criminal jury trials. Grand juries, however, did continue. And we scaled back as we had to based on the circumstances of the pandemic. But again, in early March of this year, we resumed once again civil and criminal jury trials on a limited basis. And with the further decline of the virus, and with the very good progress of the vaccination program in the state, we took further steps, notably just this past Monday, 2 days ago, we brought back all of our employees and all of our judges, with very few exceptions, are now working out of the courthouses, as of Monday of this week. So this is, I can tell you, a huge milestone for the state court system. It will allow for further expansion of virtual proceedings. It will allow, certainly very carefully and deliberately, but expansion of in-courthouse, in-person proceedings. And so that raises the question with that background, will we ever return to full in-person proceedings once the pandemic is behind us? And the answer, I believe, is no, that we will never return to full in-person proceedings. I think we've very much crossed the Rubicon with technology in the court system, as Richard hinted at in his opening remarks. We've got judges who literally, and I don't say this facetiously at all, but literally had never turned on their computers before, and they're all conducting virtual proceedings. It's remarkable. It's, I think a great example of necessity being the mother of invention. But I think for the most part, we hope that, most of those crowded courtrooms that were probably very emblematic of the New York State court system, I think most of them are a thing of the past. And again, not because of health reasons, I'm talking about when the pandemic is behind us, but for efficiency reasons, that the litigants and the lawyers simply do not need to travel to the courthouse for every type of proceeding and every type of case, and for the lawyers to have to wait around, for the litigators, or the litigants rather, to have to take off from work or pay transportation costs or deal with childcare. A lot of that going forward, I believe, will not be necessary. And the pandemic has shown us that many, not all, but many of these proceedings don't have to be face-to-face. They can be conducted virtually or even not at all. So just a few examples of what I'm referring to. With civil cases, preliminary conferences, status conferences, discovery compliance conferences really can all be done virtually unless the judge or the lawyers have a reason or some preference to conduct conferences like that in person. Settlement conferences and pretrial conferences probably could benefit from more than being in person when there's a real focus on trying to resolve the case, particularly cases that are ready for trial. More of an argument that they should be in person, although with exceptions, certainly not always. Evidentiary hearings, including bench trials. Bench trials, by the way, are trials, non-jury trials where the judges find the facts, not the juries. So evidentiary hearings and bench trials we could see a combination of both. Some could be done virtually according to the preference of the lawyers and the preference of the judge. Some could be done in person. And civil jury trials, very interesting question about can jury trials really be conducted virtually? Some states have experimented with that. I know our commission, and Hank may talk about this, has recommended piloting some civil jury trials. And in fact, we are planning to do that probably sometime later this summer, is to pilot a few remote virtual civil jury trials. On the criminal side, in terms of in-person or virtual, arraignments have been conducted virtually. I mean, everyone who's been arrested and detained by the police in this state going back to the middle of March 2020, everyone has been arraigned. Almost all of those arraignments have been done within expeditious time periods. But they're very important proceedings. And I think if you talk to most prosecutors and you talk to most criminal defense attorneys, they would prefer to have the arraignment in person for defendants who are being detained post-arrest. But there could be exceptions to that. But routine status conferences, and there are a lot of very routine status conferences in criminal cases, can be done virtually. They don't all have to be in person. And in fact, not all may even require the defendant's appearance. I think my own opinion is we bring criminal defendants into court in far more instances than is necessary. But certainly those routine appearances can be done virtually. Pre-trial conferences, similar to on the civil side, where pleas are often negotiated. Arguably, more of them should be in person, perhaps, than virtual. And then my own view, and I think most would agree, is that when you're talking about grand jury proceedings and criminal jury trials, that those really have to be in person for reasons that we could discuss. Just quickly, family court courthouses are in normal times are very crowded courthouses. A lot of the litigants are self-represented. A lot of them may face challenges using technology. We've seen that and learned that during the pandemic. So virtual can be a real challenge in family court. But one thing we've started on a very limited basis, and I think we're very intent on trying to expand post-pandemic, is to have in nonprofit organizations in the communities, houses of worship in the communities, to have virtual capacity set up in these off-site venues where closer to where people live, and not have family court litigants, particularly those representing themselves, have to come to the courthouse for every proceeding, but be able to participate virtually, remotely from nonprofit and house of worship settings in the community. So as to wrap this up, virtual will be a big part of how we conduct business going forward. As we return to the Excellence Initiative and focusing on backlogs and delays. And by the way, no surprise, the backlogs have grown during the pandemic. That was probably unavoidable, but as we return to attacking backlogs and delays, virtual proceedings, we think can be a big help to the extent that they make the court process faster and more efficient. And there are other technological innovations as well in that regard. And I think hopefully that's a good segue into Hank Greenberg's remarks.
Thank you, Judge Marks, for sort of bringing us up to date, if you will, on where the court system is. So Hank, what's going on with the commission, and where do we go from here?
Richard, let me throw up a PowerPoint that hopefully, just give me one moment. Hopefully everybody will be able to see it. How's that? Can you see it, Richard? Is it on the screen?
On the screen.
Yeah,
Oh.
yeah, I can see it. It's on the screen.
Okay, wonderful. The wonders of
You have
technology.
demonstrated your technological competence.
There you go.
Yeah, it wouldn't be good for the chair of the commission not to be able to put up a PowerPoint. I think Judge Marks's presentation is, and the end of it is a wonderful segue to the commission. And what I'm going to do in the time allotted to me is share with all of you what the commission is doing, what our mission is, some of the projects. I will say before I get into the screen that the work of the commission would not have been possible without the extraordinary support of Chief Administrative Judge Marks and Chief Judge DeFiore. Thanks to that support, the commission, I think, in the space of 10 months has transformed itself into, no false modesty, and I'm not speaking about myself, it's the fabulous members of the commission, the most prolific future-looking think tank in the country. It's produced 9 reports, thoughtful, scholarly reports in the first 9 months of its existence, and that's because of the support we've received from the court system. The commission itself just consists of 30 persons appointed by Chief Judge DeFiore in consultation with Judge Marks. I'm excluding myself when I say it's the most remarkable, accomplished, diverse group of individuals I've ever had the privilege of serving with. It includes representatives from every stakeholder group, I think, within the legal profession, big firms, small firms, legal service providers, academics, thought leaders, leaders of firms, large, medium, and small, Really an extraordinary group, upstate, downstate, and diverse in all other ways. And again, that's a tribute to Chief Judge DiFiore and Judge Marks. The name of the commission tells you a little bit about what we are created to do. The commission to reimagine the future of New York's courts. So that is to, you'll forgive the somewhat trite expression, think out of the box, shift paradigms, but that's really what we are tasked to do. We would not, I think, have had sort of the wind behind our back that we've had from our conception, strangely enough, were it not for COVID-19. Because I think, as Judge Marks foreshadowed and described, COVID-19 has accelerated trends that had been moving in the legal profession for years, in some cases decades, and just at the speed of light, transformed things and ways of doing business. In fact, you know, from the beginning of sort of the lockdown in March of 2020, I would suggest in the first 3 months of the lockdown and COVID-19, we saw more change in the legal profession and in the courts. Not hyperbole, I believe this, in the first 2 months than you may have seen in the preceding 200 years. Virtual court proceedings and the like in the New York State courts, the use of technology happened with a rapidity that no one could have imagined and would not have occurred, certainly not at the pace that we saw it, were it not for COVID-19. And I think one of the things that the epidemic exposed, because owing to the brilliant improvisations of Judge Marks and Chief Judge DiFiore, they literally from scratch had to improvise a virtual court system. And in the process, they made do with the tools that they had. But in fairness to everyone, no one could have imagined, and no one did imagine or foresee what COVID-19 would do to our way of life. And in the process, it revealed certain limitations in just the technological capacity that all three branches of government had built up and relied on up to the moment of the virus. I will not read the entire mission statement to you, but some of the highlights. Our goal, our mission, if you will, is to help the court system and the users of the court system to adjudicate cases more quickly, more efficiently, and in the process, help close the justice gap and enhance access to justice. Almost from day one, Judge Marks and Chief Judge DiFiore had us busy. Our first meeting of the commission, we actually approved a report. We've been given tasks both long-term and short-term, and one of the short-term goals the court system asked us to do was provide some assistance, some guides to how the courts could begin to open up grand jury proceedings, jury trials, and the like safely and consistent with public health norms. So our first report literally was approved at the first meeting of the commission. The guiding principles that sort of overlay and inspire us. One is to focus on the consumers of the courts. No disrespect meant at all to the judges and the employees of the court system, but the courts weren't put there to enhance the efficiency of the judges and staff. It was there to serve the public and provide a means to resolve disputes, civil and criminal. So we are laser focused on the public for whom the courts were designed to serve, increasing access to justice, and of course, delivering services more efficiently. I meant it when I said before that the construction of the virtual court system was miraculous, unfathomable before the COVID. No one could have conceived, just to talk about the appellate courts, no one could have imagined that in the space of several months, appellate proceedings would be entirely virtual, oral arguments virtual, court conferences virtual, all filings electronic. Utterly unthinkable before March of 2020. And so we have seen literally a digital transformation. And I expect we are going to see more of that in the weeks, months, years, and decades to come. It's an interesting fact that today more people in the world now have access to the internet than access to justice. It's a sad fact, but it is a true fact. More than half of humanity is now online. We are experiencing throughout society a tsunami of change that technology has wrought, and that change is ever accelerating. The digital transformation, and one of the things the commission is all about is helping the court system to leverage the digital revolution in society. And I'll explain some of the ways, some of our early recommendations are suggesting that. And also to bring the court system into alignment with advances in the digital world. Now, if we were having this conversation in January or February of 2020, I would have said, well, no, we're not there. And that's not meant to be a criticism, but clearly sort of the use of technology and other walks of life you didn't see in the courtroom. And like that, we are now there. There's more to go, but the changes have been extraordinary. A word or two about the process of the commission. We meet every 5 to 6 weeks. Our meetings feature presentations from national thought leaders. No one has said no to us, and it's been remarkable. We have spoken to the Chief Justices of the Michigan Supreme Court, the Texas Supreme Court, who also is the head of the Conference of Chief Justice of the United States, a judge who's a thought leader out in Utah, academics, and others. As I said before, we're working on long and short-term projects. Post-COVID, I think we're hoping to eventually do public hearings and the like. In the meanwhile, we've done targeted outreach to stakeholders, 10 reports in the first 10 months. The commission from day one was committed not to spend years working on a hundreds of page tome that might collect dust on a shelf and that events would outpace. So we're trying to produce in real time reports that are of value to the court system. How we are organized will tell you a lot about the work of the commission. The commission itself is a full group of 30 commissioners, meets, as I said, once every 5 to 6 weeks. But the real work of the commission, the day-to-day work, is in 6 separate working groups. That while there's overlap between these working groups, as I'll explain in a moment, are all working on different projects, are all producing and have all produced reports approved by the commission and then shared with Judge Marks and Chief Judge DiFiore. The technology working group, just to sort of start with it. This group is and does what you would think it does. These are technology wonks. They think software and they think hardware. They're all about looking and thinking of ways for the court system to sort of take the next step and go to the next level in terms of just sheer technological capacity. So it has already surveyed 9,000 judges and court staff, begun to produce reports to Judge Marks, including assistance with the reconstruction of court system's website. Long overdue, so like so many organizations, that work is already beginning, possibly restructuring the Department of Technology that has performed magnificently under the most dire circumstances during COVID. The work plan of the group, I just told you a little bit about, but like I said, it is focused on the sort of thing that you would hear if you went to a technology conference. How do you do virtual better? What is the next generation of technology? How, if at all, should the court system move its systems from sort of hardwire infrastructure to the cloud? Those are the kinds of issues it's looking at. The online courts working group, while similar to technology, is different. This group is chaired by 2 leaders in the profession, Brad Karp, who is the counsel, rather I should say, the chair of Paul Weiss, which is a large firm in the city, and Mylan Dennerstein, who is a partner at Gibson Dunn. Online courts, I think most people will agree. The idea of actually handling cases, not just virtually doing oral argument, but processing, adjudicating cases virtually, is not whether we will do that, but when we will do that. It's already happening in the UK, parts of Canada. There are 16 states in the United States that have pilot projects that are underway with respect to smaller matters, traffic court, small claims matters, creating virtual platforms where litigants don't have to spend perhaps a day in a busy courtroom waiting for the case to be called, but can actually, just imagine in traffic court, not spend a whole evening waiting for their traffic ticket to be handled, but to do all of that through electronic platforms. The group has already produced its first report, which has suggested pilot projects, which I'm so pleased and proud for the commission that Judge Marks and Chief Judge Fiore have already sort of supported some of that important work. And you're going to hear more from this group. It is now putting together a survey of practitioners and getting their ideas and thoughts about ways to bring cases online in new and different ways. And one thing I want to be clear about, this group isn't sort of dealing with eliminating trials or really dealing with complex litigation, commercial or criminal. But it is looking at ways to deal with housing court matters and other kinds of matters that more efficiently and from the point of view of the litigant in a more user-friendly way allows them to handle these cases. Obviously, we're focused on the idea and know full well, not everyone has access to the internet. Not everyone can afford a smartphone. Not everyone has a laptop. And still in New York, hard as it is to believe, there are broad swaths of the state that still don't have broadband access in the Adirondacks. So this project is not something that can be executed, overnight and yet statewide. But like I said, it's not a question of whether, it's when. And you can be certain 20 years from now, whole categories of cases will be processed, not in courtrooms, but on digital and virtual platforms. The Regulatory Innovation Working Group, as the title of it suggests, is looking at regs, codes of ethics, laws that are currently in place, and trying to propose reforms that can enhance access to justice. Let me give you an example. The first report of this working group addressed a subject that is across the country getting an enormous amount of interest, not just in the scholarly community, but in many states in the West Coast and the Southwest, are dealing with experimentation, dealing with certain ethical principles that in New York are in the minds of some sacrosanct. Non-lawyer ownership of law firms is prohibited in New York. Fee splitting is prohibited. The unauthorized practice of law is prohibited. Some states have modified those rules in order to provide greater access to justice. So for example, clients who can't afford attorneys and for whom legal aid societies in those states are not accessible, there are experiments in some of these states to allow paralegals to perform certain kinds of services. This is a controversial issue in New York in particular. Many of our bar associations feel that these principles are foundational and shouldn't be tinkered with at all. And New York, let's face it, is very different than Utah, which has been experimenting in a whole bunch of different ways. Most notably, no state has more admitted lawyers than New York, over 300,000. No state has more resident lawyers than New York, 180,000. And no state is as diverse as New York in every way, geographic, ethnic, religious, in every way imaginable. Our first report from this working group actually looked at that issue and ultimately concluded that the data produced by those states that have been experimenting isn't compelling enough to yet recommend changes to these principles I described. But it did recommend, and Judge Marks and Chief Judge DiFiore are in the process of implementing, allowing social workers, for example, to be more engaged in courtroom proceedings and family court matters. That's already been happening. Legal aid societies have been using social workers quite a bit. So what this working group is doing, and many family court judges would rather deal with a social worker who's trying to navigate a familial dispute than the attorneys. So trying to find an enhanced way for social workers to provide assistance to litigants in family courts was one recommendation that is now being in the process of implementing. I've just told you a little bit about the work plan. Let's move to the structural innovation group. We have a unified court system in New York. It is one of the most daunting and Herculean challenges imaginable to try to unify a court system as diverse and complex as New York. Why? 63 counties, all have their own county courts, all have their own county resources. The clerk of the Supreme Court in those 63 counties, guess what? Is not the clerk of the Supreme Court. It is an independently elected individual known as the county clerk, most of whom in New York State are not even lawyers. And so Judge Marks and Chief Judge DiFiore have to find a way to take these 63 counties with court systems funded to a significant degree by the counties and bring them together. And there are structural obstacles and roadmaps and hurdles that make that different, including a state constitution, 1/3 of which, 1/3, is devoted to the judiciary. Virtually everything involving the court system, I'm exaggerating a bit, but a lot, I think Judge Marks would agree, is in constitutional cement, can't be changed. Compare that to the federal constitution and the federal court system. Article 3, which governs the court system for the entire United States, fewer than 400 words. So there are all these obstacles, and this working group is looking at them. And I'll just quickly talk a bit about their first report, which deals with something that in 49 other states is not a hassle, because in 49 other states, the court system is not dealing with a constitution or a court system with so many statutes adopted by the legislature limiting the discretion and flexibility of our court system leaders. E-filing. The legislature has deemed it appropriate for that branch of government to literally micromanage the commencement of lawsuits in the e-filing system. We're now very close, after years and years and years, and after the federal court system has been digitalized with e-filing for over 2 decades, we're now just a few counties away from having a statewide e-filing system in some categories. We are way behind the rest of the country, way behind with respect to e-filing. And that's because of the structure over which Judge Marks and Chief Judge DiFiore have relatively limited control. The next report of this group, they're studying it now, is something that in the other states isn't a complex subject for the court system to manage. It's the Civil Practice Law and Rules, the CPLR. Over 10,000 rules compared to the fewer than 100 federal rules of civil procedure. If Judge Marks and Chief Judge DiFiore wanted to change the CPLR, could they? No, they can't, unlike court leaders in virtually every other state in the country. The legislature controls it all. That might have made sense when the CPLR was created in the early 1960s, when over 2/3 of the legislature were lawyers. With short legislative sessions, they were not only lawyers, they were practicing lawyers. But that can't happen in New York.
Hank, I just want to make sure Lance has an opportunity to give his remarks, so.
Okay, so I'll wrap it up. The last 2 working groups, the trial working group and the appellate working group, are looking at the kinds of things you would think of. They're actually focused on the weeds of trial court and appellate proceedings, and they too have produced reports with respect to the enhancement of efficiency and those 2 basic courts. So happy when Lance is done if anyone has any questions, but thank you all for listening.
Thank you
And
very
thank
much,
you.
Hank, for telling us about really a very informative discussion of what's going on. And now, as I said at the outset, Lance Clark, who's been looking at all of this, looks at it from the perspective of the practitioner in a small firm. And let's hear from Lance and get his views.
Oh,
Yeah,
and I'm
thank you.
afraid before, Lance, sorry, before you start, I just need to share the code for the CLE forms that folks have, which is just the word justice. Let's see, Hank, if you can cancel your screen share, I will put mine up.
Okay, I'll do that in a sec.
All right. But again, it's just the word justice, lowercase j. Doesn't actually matter. It's not case sensitive, but I will put it up on the screen in just 1 second. Actually, it looks like I can do it. There we go. Should be popping up on your screens now. I'll leave that up for just 1 second, but again, it's just the word justice. All right, Lance.
Okay,
Take
thank
it
you very
away.
much. Let
Thank
me first say thank you very much to Richard for the invitation to present, and also thank Judge Marks, and of course, definitely Hank Greenberg and the commission for the amount of work, the volume that they have produced in a very short space of time. We all know that COVID-19 is a pandemic that hit us when we didn't expect it. And the aspects that it has of the aspects of life have really been complicated, much more than we anticipated. The impact on the court system, of course, of New York, the busiest court system in the country, especially downstate, has had its share of impact. And of course, I know that the system has been trying very hard to stay ahead of the complications. Large firms and small firms alike must comply with new laws and new rules made to facilitate practice through technology designed to assist us to be being ahead of the curve, so to speak. The curve is steep, but attorneys and courts must meet high expectations of the general public that puts its trust in the competence of the New York Unified Court System. And, let me say that looking at the time, I will say that as if I was before the Appellate Division, Second Department, I rely on my brief. My outline is there and it may be downloaded. COVID-19 has hastened the introduction of a new era. Most practitioners, particularly folks like myself, thought that times would change gradually, that new technologies and emerging new technologies would be phased in over a much longer period of time, and that the new rules as well and new laws that impact practice would also be changed very gradually, or at least give you a chance to be able to digest them. But in point of fact, it has come about rather quickly. And of course, judges, attorneys, litigants, jurors, we have to adjust to the new legal environment, even in a climate that it's despite insufficient personnel, physical space, lacking the latest technology, and limited funding. And maybe funding is probably the most important aspect of what the change is bringing about. Obviously today, particularly for small practitioners, clients expect work done yesterday, not today, yesterday. And of course, particularly if you have larger clients and you're a small office, there are also benchmarks that you have to meet, whether they are for discovery, even service of process, discovery and timeline for trial. People want things yesterday. So in point of fact, having to get your office up to snuff to deal with new technology, as well as dealing with internal pressures of production, as well as external pressures from clients, you have to be able to meet pressure. It's a pressure society that we're in. COVID-19 and curing the pandemic, of course, the assessment of the legal system. One of the most often things that I've been hearing is that attorneys say they want the system, the unified court system, to take into consideration that the fact that there is the broad practice of law. Law officers have different capabilities. And what do I mean by that? Yes, and as I think Hank mentioned, there are parts of the state that broadband internet they're not capable yet. And that makes it difficult. There are also other reasons, such as, not just geographic, but also you have some attorneys have aged equipment and they don't have the latest in software. Also, small offices usually don't have an IT department or an IT consultant that can assist them with training the attorneys as well as staff. Because of course, today's law office, for the most part, staff does an awful lot of work and the attorney does the actual trial. Also, with respect to learning software today and getting your computer up to snuff, that the attorney, a small office, the attorney has to become versed in the ability to do the latest of research or the latest of utilizing these software and different items as they come along in technology. And of course, that's downtime for an attorney, especially when you have to be able to not only be able to load the software, learn it, and be able to use it effectively. And that's without considering the expense of software. So there's, in short, there's a difference between the imposition of rules and new laws and technology and to achieve a desired result. But reasonable and practical expectation has, you have to have a reasonable and practical expectation in order to gain the successful compliance of the persons that you hope to be able to implement what is necessary to get the job done. And what am I talking about? The disparity in the ability to practice law, of course, using new technology, it could drive some practitioners out of business. I think of the younger, small attorney wanting to open an office today. Today's young attorney, a lot of times has high college debt, high law school debt. And because of both of those things, with the investment that it takes to open a practice now, that can be inhibiting. You also have the senior practitioner who is just getting used to using a computer software, Zoom, Skype for Business, Microsoft Teams, and other emerging technology, and they may be forced into retirement. So those considerations have to be taken by the commission when it's looking at this. Every lawyer is not tech savvy and will take time. And I know, because when I started practicing law in the late 70s, I can tell you that, and I know Judge Marks probably knows this, and Hank as well. When you did legal research, you went to the law library and you came out of the law library with some case law and maybe the statutes, and you shepherdized and you wrote a brief, and you wrote it on a legal pad. There was no computer to put it in at the time. Today, you can be sitting in the courthouse and on your cell phone call up on Westlaw or LexisNexis what is necessary to be able to go to the judge and say, Judge, a case just came out an hour ago that can be used in a case. So that all of that I'm saying is shifting gears is not as easily and readily available to everyone, and that should be taken into consideration. But despite the limitations that we have, varying abilities, capabilities, judges and attorneys must strive to come into the era of emerging new technologies. The practical considerations for the courts, of course, and as has been said already, Judge Marks said it, every litigant, no matter the addendum in a civil case or whether they have a criminal case, they expect that their case is the most important. So there's no question with respect to that. We have to do those things that make sure that their first experience with justice is a good one. And that means that judges and law clerks, with respect to implementing the new technology, have to think outside the box, and Hank said that. I look at the most important thing as being that we comply with, as is said in the report, First and Sixth Amendments of the United States Constitution have to be complied with, and it seems as though the commission is looking at that very closely, and that's a good thing. Of course, I don't want to see New York make the mistake that California made in making mandatory virtual trials, especially jury trials. And obviously, if you make it mandatory, possibly you're going to have more appeals. But the focus, as a small practitioner who spends a lot of time in district court, landlord and tenant and family of court are probably the two most backlogged courts. And those are the courts that litigants are most likely to see during their lifetime. And because of that, focus on technology and bringing those courts up to speed would be very good. And as I said, Texas and Florida that are recited in the report, I'm not so sure that the heart was really in it, but I see the integrity and the push by this commission, and they appear to be doing a good job. Pretrial conferences and video conferencing are going to be the wave of the future. Anybody that doesn't think so is making a mistake. And the most important thing in virtual conferencing I've found because I do it as a special referee for the appellate division as well as being a practicing attorney. I think the most important thing is the judge has to be in control. The judge has to control the environment and all of the small items, all the simpler items, benchmark hearings, discovery, oral argument, motions, pretrial considerations, all of those should be done virtually as best that we can. That will help to eliminate a lot of nonsense, a lot of people in the courthouse. The participants, of course, I think for the most part will appreciate that. They get to stay where they're at. The benefits: reduced traffic in the courthouse, reduced stress for the court staff, judicial control of conference scheduling, reduced probability of adjournments, reduced wear and tear on court facilities, save travel time for attorneys and litigants, increased attorney office productivity due to reduced travel time, reduced attorney billing due to reduced travel time, reduced stress on parking facilities proximate to the courthouse. I can't imagine how many times I've ridden around Queens County Court trying to find a parking space if I couldn't get in a lot. And as my boss used to say when I worked for a major litigation firm many, many years ago, he used to say, going to court was hurry up and wait. Well, I think we're going to make a dent in that. And I think that most practitioners appreciate the ability to remain in their office and get a judge on the phone or be on video conference. Infrastructure considerations, and I know we're running short on time. In my outline, I have a picture of Nassau County Courthouse. That courthouse is vintage 1938. Trying to retrofit that courthouse would be a nightmare. Construction costs will be ridiculous. And I think that the most important thing that it is a nice recommendation by the commission about public-private partnerships to get sponsors that would possibly support the courts. But that may be a problem for the bidding and competitive bidding process, because a lot of times vendors will also be on the state bid, or they will be bidding on state or local projects. And obviously they wouldn't want to run into that problem with respect to a possible conflict of interest. But looking forward, alternative court facilities, rental space. The courthouse that I just mentioned, built in vintage 1938, would be fantastic to retrofit it, but the cost will be astronomical. There may be high-tech or high-speed broadband internet-ready buildings. You could take a floor and put a virtual courtroom on that floor and be able to save a lot of money. And the legislature very well may go along with it in terms of financing that type of temporary space or even permanent space. And I think of right off the top of my head in Hauppauge, where the grievance committee is for the second department, that Citibank just moved out. Now, you can't tell me that a bank doesn't have internet ready space and it wasn't made ready for that. That might be an alternative for the future of a virtual court setting, possibly getting that type of space. Also, alternative funding. Nassau County Supreme Court is actually the location for coastal evacuation for the I guess it would be Southeast Long Island. If you're in Long Beach and you have to get out because of flood, like Hurricane Sandy, the coastal evacuation location is the parking lot for the Supreme Court, which is now between the Supreme Court and the new family court that is being erected now. There may be infrastructure bill money as well as FEMA money, because if you heard yesterday, the president just raised the amount of money from $500 million to $1 billion available for disaster funding. And that there may be part of a bill. So our legislative person should be solicited for the purpose of trying to get some dollars and cents. It very well may be the think outside the box type of things. Where's the money? And get it. I'll try to summarize fairly quickly. The personnel considerations, I remember when I started practicing, JHOs were very popular. They brought back to Queens County, where we were trial counsel for Liberty Mutual, and they brought back JHOs to handle calendars. They did a good job. We had 325D knockdowns that were transferred from Supreme down to civil, and the judges handled those, and JHOs had some of those assignments. That might be something, because bringing back those who were furloughed just last year or those that retired may not be enough. If there may be others that might be willing to serve, it'd be a win-win for the court system. Obviously, handling litigation would reduce the backlog, and at the same time, the judges would have an opportunity to promote justice from the bench once again. I mentioned another judge that I have, Gerald Carter, who was a county court judge, 20 years on the bench in county court in major felonies, as well as a major felony trial judge. Excellent person to bring back to do some JHO work, even if it's mediation and settlements. They can handle those type of calendars. For landlord and tenant, there's just retired from district court. Scott Fairgrave is now the village justice of Mineola. Handled landlord and tenant, was a superior judge in that part. Could possibly, if something could be worked out with the village and town justices or the village administrations, where possibly those judges could serve part-time as handling a district court calendar. They already handle the traffic and parking court calendars for Nassau County. So that might be an option for the system. And then the last two things I have is guidance for judges, of course, as technology emerges with virtual reality, different types of evidence that are coming in, some of the things we're seeing. It would make sense, of course, CLE focus, and maybe there should be some mandatory CLE on technology so that our attorneys are constantly coming up to speed and find out what's available to them, maybe not at a ridiculous price. Also, judges, we have the Judicial Institute. I attended that when I was a village justice. And of course, the training is superior, but judges are going to have to constantly be given updates because evidence is changing. The way it's coming in is different. Taking a Zoom set of evidence is different than taking it in person. Matter of fact, I had a case where I just realized that I was looking for where's the yellow markings that the court reporter used. Well, they weren't yellow because we pre-marked evidence with the virtual conference. And so therefore the reporter had a set and they were all mailed by counsel. I want to give kudos to Norman St. George. He's done a fantastic job. The virtual bench trial protocols and procedures manual is excellent. And hopefully there will be a companion jury trial. It'll be a lot more difficult to put together and a little bit more technical, but he and his colleagues did a fantastic job in putting that together. I use it. I found it to be quite helpful, particularly the nitty-gritty things about what do you do with a difficult witness, or make sure that the protocols, attire is proper, make sure that things are pre-marked, and what conferences counsel should have in advance. Those are great suggestions. It cuts down on trial time. Also, summary jury trials, maybe it should be promoted a little bit more through the bar associations. I'm sure they would be willing to put it out. And if an evaluation team could be put together that would screen cases, take a look at the cases as they come down before compliance conference, and maybe suggest to counsel, get the counsel together and have an evaluation situation with the future trial judge, and possibly you could get a stipulation that the summary jury trial would be the way to go. Cuts down on the amount of time once more. And there, a lot of times attorneys hope that there is a settlement tactic to hold it up as much as you can. If you get down to a summary jury trial, very well may eliminate much of the backlog for getting those cases that are not as complex out of the way. And last but not least, I just said in my conclusion that, and I want to read it because I feel it's important. And it's once emerging new technologies are regularly offered in evidence in New York courts, such technologies are destined to become an integral part of future court litigation. Law firms of all sizes will have to prepare for this reality. The legal profession must prepare to move forward wisely in a diligent and cautious manner, always mindful of the impact of emerging new technologies on equal access to justice. We must also acknowledge that emerging new technologies will require the implementation of new laws and court rules to regulate their intervention in litigation. Issues that will need to be addressed on an ongoing basis include economic inequities of litigants and practitioners, disparities caused by differences in attorney and judge familiarity and comfortability with new technology, as well as the financial limitations of both the practitioner and the unified court system. Consideration and continued evaluation of these issues will be required to ensure equal access to justice in the state of New York. And I hope that I've been able to assist you in discussing this topic today. I want to thank everyone for the opportunity.
I would like to thank the three speakers for just wonderful presentations, all of which were, I think, exceedingly informative. We've seemed to have run out of time and actually run beyond our time.
Yeah.
I suspect that we're going to have to pass on questions and answers. But again, a very, very large thank you to our three speakers.
Yes,
Thank you.